Good afternoon. Welcome on in to the afternoon edition of From Day One. The lawyers, the courtrooms are all ready, and they're all finally heading back to their normal lives as Johnny Depp and Amber Heard are finished with Johnny Depp coming out the winner in that case. Today, though, we go to Kansas, where a judge gets himself in a little bit of hot water. With us is Law Talk with Mike and a great lawyer from the state of California who is with him during some of those Depp Heard trial situations. So, lawyers, if you'd be so kind, take it away as we march through Dominion.
Here we go. Oh my gosh. Your Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye.
Ooh.
All persons having business before this court are admonished to draw nigh and give their attention to the court.
Supreme Court.
Good afternoon. Welcome to all of you, both on the Zoom or within our court Zoom call, as well as those who are watching us on our Supreme Court Live channel. I will now ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call this afternoon's docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Thursday, October 28, 2021 consists of one case. Appeal number 123911 in the matter of Marty K. Clark, Magistrate Judge, Original Action and Judicial Discipline. Your Honor, the examiner for the Commission on Judicial Conduct has reserved 5 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima.
First of all, it strikes me as odd that they're doing a hearing for the Supreme Court via Zoom, but that's what they're doing. It's pretty cool. And the guy bottom left, Todd Thompson, is effectively the prosecutor. The guy bottom center is basically the defense attorney. I mean, we're at the appellate level, so they're using different things, but I'm keeping it simple. Yep. And the guy bottom right is the judge who's in trouble here. That's the hot seat. Bottom right, hot water.
Counsel, will you please state your appearances?
May it please the court, I am Todd Thompson, appearing as examiner for the Commission on Judicial Conduct, present and ready for argument.
May it please the court, Chris Joseph, appearing on behalf of Judge Marty Clark, who's also present. I'm present and ready for argument.
Thank you, counsel. Mr. Thompson, you may begin your argument.
Thank you. This proceeding arises from a recommendation for judicial discipline from the Commission on Judicial Conduct.
Okay, I'm going to stop it right here before we get into it. Each side gets 10 minutes, and there is a clock since this is a Supreme Court style hearing. This isn't just a straight court case. So with 9 minutes and 55 seconds, my apologies, I'll let you continue, Counselor.
The respondent in this matter is former Magistrate Judge Marty K. Clark.
This came up too. I like this stopwatch they have up here. Everyone kept asking us about this during the Depp Heard thing. They had a little clock up there, but this is a typical of appellate courts. I've never been to any Supreme Court. I haven't been to the Illinois Supreme Court, but I've been to the appellate court, and they give you, it's real specific on the time, just like this.
Well, I will tell you a fun little fact.
Yes.
In the United States Supreme Court, which I've had the occasion to appear before once.
Oh, that's cool.
There is an analog clock above the justice's head.
Right.
But the rule is never look at the clock. I mean, if you're on your feet, don't look at the clock.
Yeah, you better be on your game for that gig. That's a cool experience.
Okay.
From the 20th Judicial District. Judge Clark retired during his term of office after the initiation of this action. This case involves Judge Clark's participation in a website self-described as an online community for swingers, and with regard to his related activities. Judge Clark posted nude and partially nude photographs of himself and others, and gave access to others to view the photographs. Judge Clark maintained an account at this particular website on and off for multiple years. During the years of his subscription at the website, the judge paid the fees required by the website for giving access to others to the photos and information about the judge and his wife, and for gaining access to photos and information about other subscribers to the website. The website is used by subscribers for the purpose of connecting with other couples, which the judge describes as a dating website for couples. Some subscribers make connections that lead to sexual encounters. The account that was maintained by Judge Clark and his wife listed a false zip code and altered names, which we argued at the hearing before the panel revealed his awareness of the impropriety of his conduct. Judge Clark met the complainant and the complainant's wife in the late spring of 2019. They met at a bar, conversed, and after that meeting, Judge Clark and the complainant's wife began communicating via text message and email. I will refer to the...
Hi, Sean. Just to catch up, we got a judge that joined a swingers website. It's good times, and then a completely reasonable discussion breaks out here. So, but it is funny. This guy who's Todd Thompson, who's basically the prosecutor, is laying out a nice case, and he is so stern about this. Is beautiful. All the justices, to their credit, hold it in, but Justice Rosen, he never does, but he's on the verge of cracking the entire hearing.
Well, I mean, is there more to it where he does something on the website, or is it just the fact he did it?
Just the fact he did it. You shall see.
No, not just membership. You, in order to be on this website, you gotta show the merchandise.
Okay.
Well, he took pictures of his junk and made it semi-available. These are all good questions. These are exact questions that come up here.
Hey, if he's proud enough to put it online, then he's not embarrassed.
I assume that we're talking about judicial canons, right? Not just what.
Yeah.
And that's what Sean, you're not going to get in any trouble for this.
Right.
No,
It's not illegal. This is an ethics.
Yeah,
this comes up from an ethics violation.
Oh no, I know this is a judicial disciplinary hearing, but it's like
Yeah. I know, and I get this all the time from people who are upset with me. They say, "Oh, the attorneys and judges are above the law." No, we've got more restraints on us than anybody. Believe me.
I mean, if he's on Tinder, will they be as mad?
I hope not.
The judge's paramour from this point forward. The judge and his paramour discussed in very graphic terms their attraction to each other and the prospect of having sexual activities with each other. Their rather salacious texts included messages wherein Judge Clark and his paramour actually discussed the details of a wished-for sexual encounter in the judge's chambers.
Can I ask you about one of those exhibits? And I won't get into the details of the dialogue that was occurring, but it's graphic as you described. One of the
we can all imagine, but thanks, Judge.
No, Justice Rose is like, can we actually talk about these text messages? And
I want to know.
Oh, by the way, I'm losing internet connection. I'm gonna have to dump my video for a minute. Just tell me about it. No, that's what he's saying. Go through it slowly, though.
I don't know. Maybe it's because I practice law, but I don't find anything hot about judges' chambers. Let's just start there. It's everyone teach their own, but it's just not on my list.
questions I have is that it appears that it has a time stamp on the time in which the texting was taking place, and it says 2:16 p.m., and I assume that's in the afternoon. And then one of the text responses referred to, I should not be wound up on a Tuesday. Can we infer from that that was occurring during work? Or what do we take from that? And if we can, does that make a difference?
I don't know that it makes a difference, although it might make it worse. You can take that there were texts because there was evidence before the panel of the timing of the text. The text occurred during the day. The judge denied that it ever interfered with his performing his duties, but with
Oh yeah, I mean he's dropping this text in the middle of somebody whining on about some bad motion for summary judgment that he doesn't want to listen to.
Oh, okay, that's an issue. That's an issue.
Was he on the bench? No. It was
Well, I guess it's during work hours. The rest I'm kind of putting, but that's the text message. I shouldn't be this wound up on a Tuesday. Tuesday during business hours, he's probably on the bench.
I wasn't aware that Tuesdays were a day never set aside though. As a man, I feel, especially at my age, anytime you can get wound up.
Okay.
Good for him. He should get a commendation.
This is like the Massachusetts Bay Colony Bar Association, I think, at this point. He doth thought about fornication.
Oh my God! A
The good Lord to walk.
good historic reference there. I love it.
You guys are both gonna like the justices' questions. You really are.
without question, they were texting back and forth during the court's business days.
All right, we got you.
Going on, I would note that during this discussion about having sex in his chambers, Judge Clark readily identified his chambers as being in Russell, Kansas. Photographs of Judge Clark, most of which had been stored on the subject website in the judge's profile, were admitted into evidence. Those photographs have been sealed or were sealed by the panel.
Counsel?
Yes.
I'm sorry to interrupt you, but your time's running down. And
I like this guy.
I guess my question, I'm trying to think how to frame this appropriately. And I guess the question is,
that ship has sailed, man.
Do you have any concern that this proceeding is treading inappropriately into the private life of the judge? I'm just trying to, is the recommendation of discipline and the violations entirely founded on the moral disapproval of this behavior, or is there something else? I guess that's the right question to ask.
He wants to take this.
Well, I would note for starters, this court's opinion released in February of this year, indicating that Canon 1, Rule 1.2 demands that a judge act at all times, meaning 24, and I'm quoting the opinion now, meaning 24 hours a day, 7 days a week, 365 days a year, in a manner that promotes public confidence in the independence, integrity, and impartiality of the jury, or of the judiciary.
And does that, so what is the standard that we apply to entirely private behavior? I'm trying to figure out if
because
this
he
case
disagrees
has any kind of
about being on the clock 24 hours a day,
or if this is just all of this.
Yeah, I mean, I don't know a judge alive that could withstand that scrutiny. No. I'm sure he's citing a rule, but
he is. Yeah,
you're saying that nobody does anything that wouldn't, promote the respect of the judiciary 24/7, 365. Mm-hmm. No way.
How about on the bench alone?
Yeah.
I mean, you don't have to come on to private life.
Sure, right. And I think the funny thing is these, the Supreme Court justices, if, when he says it's like, oh, you're always on the clock, I bet they're all thinking like, yeah, no, we disagree, boss.
Meanwhile, every one of them is currently a judge or a justice in the Supreme Court, and they're thinking, they're pondering, have I done anything that's not
Is there any way for me to erase my browser history while we're doing this hearing?
Yeah, as we speak.
Right,
well, this is where he should have said, like, the guy investigating should have said, Your Honors, I demand you all stand up. I want to know who's wearing pants.
Right.
Which are unpleasant, I'll say, have come to light, and it embarrasses the judicial branch, and that's the grounds on which we're going to find a violation.
Well, I would argue that these details are not private. That's why these photographs were at a public hearing. That hearing was public. The decision was made not to or to seal them so that they wouldn't be circulated in the public. But a complaint came in from a member of the public, so it's not private. Second, the judge is subjecting himself, when he engages in this type of conduct, to the possibility of being intimidated or blackmailed by people who have these photographs.
And there's your problem.
In this particular instance, the complainant opted to...
How far does this extend? And let's just, again, it's unpleasant to talk about this, of course.
If they hadn't sealed it, they wouldn't know the answer, I guess.
Yep.
Well, this is where it's like,
That's why double entendre.
maybe there's a blackmail, but if this dude's got like a monster hog, hey Judge, we're gonna tell the world you got a big Judge, we're gonna tell the world you got a big cock. It's like, oh no, don't do that.
Family, come on, man. I'm a rabbi. Come on.
Oh, I'm sorry, Rob. I'm sorry, but like,
it's happy hour. It's happy hour. Let's talk about Mike.
So I want to say, Mike, you may know this, and I jumped in a little late. When he took his pictures, did he refer to like, oh, by the way, I'm a judge in Pig Knuckle County, Kansas, or something?
No, he said they were talking about doing it in chambers.
Well, no, I know that. But, like, in his profile, like, my swinger profile, like, by the way, I'm the judge here,
right.
I'll give you some justice.
I thankfully did not see the swinger profile.
Oh, all right. Well, I didn't know if they alluded to it or not.
Let's assume that a judge is having an affair. An old-fashioned affair, if I can call it that. Is that enough by itself?
A good American old-fashioned
to find a violation?
I think
absolutely laughing.
You probably need a little more detail, meat on the bones, but yes, I think it's quite...
Why do you need more? Isn't that judge also subjecting him or herself to public embarrassment, blackmail, all those other kinds of things? So under the logic of the way this case has been prosecuted, I'm finding a hard time distinguishing that hypothetical.
Well, I don't think you need to distinguish that hypothetical. And there is case law cited in the record that says, for example, adultery in Connecticut. There's a Connecticut case cited. Adultery is not a criminal act in any way, but the court has held it still can create a situation where the judge is vulnerable, and it can create a blemish on the judiciary.
So and again, I appreciate the straightforward answer. I'm just exploring where these lines are, but it sounds as though the position you've taken is that judges are held to...
You held what?
I suppose the right way to say it is the standard, the broadly acceptable standard of private behavior, especially with respect to their sexual lives. Is that a fair way to say that?
I don't know that I'd say especially with respect to their sexual life. I just think if you accept wearing the robe, you accept restrictions on how you can behave, and that you have to act.
We would all agree with that. What we're trying to discern is what those restrictions precisely are.
Well, again, it has to promote public confidence. Does this kind of behavior promote public confidence? Absolutely not. Does an as you called it, old-timey affair or old-fashioned affair promote public confidence? Absolutely not. Does it endanger the independence of the judiciary? It absolutely does. And I see my time is up.
Thankfully. For you.
Are there other questions? Counsel, it used to be that drinking liquor in public was verboten. It was very dimly viewed by the public. How do we ascertain those societal mores other than simply to look within ourselves?
Well, I think you have to look into yourselves and society. You need to get out more. But I mean, we all have
I wish I could do it
slightly different.
Thanks for coming by, Rod.
Sorry,
Appreciate
Rod.
it.
Thank you, Rod.
I'm not saying that there's a red line that is the same for everybody, but we all have standards that we think are appropriate or inappropriate behavior. And the good news is, in this particular case, we're not even close to the line. We're so far beyond the line that the panel voted unanimously. It wasn't like it was vague or uncertain here. So I don't want to get caught up in a academic discussion that is not necessary in this particular case.
But the bottom line is, the conclusion of the panel was that the conduct in question violated the code because it was so far afield from the established line, which is some moral compass. And I think the questions that I've heard today, I'm echoing perhaps, but that moral compass, are you suggesting it's just you know it when you see it, or are there factors that can guide our discretion in identifying what that moral compass is?
Well, I don't think I use the term moral compass because I'm not sure this is just a matter of morals. I think it's something different than that. Again, I think the question is, does this kind of behavior promote the public's confidence in the judiciary, or does it detract from that? My conclusion and the panel's conclusion, it very much detracts from that. That's not a moral decision. That's an awareness of how the public reacts to this kind of behavior. Does it promote the independence and integrity of the judiciary? I mean, these are the terms from the code. Again, absolutely not. There's nothing about this behavior that makes you think this judge is above reproach, or that this judge might not be intimidated or blackmailed by someone who has possession of these photographs. So that in turn impairs that judge's potential impartiality. So all of these dominoes fall over when this behavior occurs. And again, I don't think this is just a mere where are your morals. There are some standards set forth in the code.
There are other questions. Thank you, Mr. Thompson. Mr. Joseph?
That actually shocked me when he gave his opening statement and said what happened. I thought the court would just roll over, but this guy got grilled by them.
Yeah, I mean, like, all the jokes aside, could there theoretically be some blackmail? Maybe, but it also, he's going to be involved, like, no matter what you do. Let's say he's involved in the Freemasons, or let's say he was doing this on the down low and he wasn't using the internet. Like, if somebody still finds out about it and then goes, like, runs and like, oh my god, he could be blackmailed for this. Like, he could be part of, like, I don't know, a stamp collecting club, and everybody like, oh my god, he's such a dork. Like, there's a million things he can do. Like, and I think we all have something that, like, it's kind of like a guilty pleasure, and if we told the whole world about it, it'd be kind of embarrassing. And, like, I'm not going to lie, when I first started doing this, this was kind of like, I was kind of a little bit embarrassed by it. It's like the next time my girlfriend told, my parents, like, I was doing this, I'm like, shut the fuck up, like it's not good. But, like, but everything is embarrassing to somebody at some point. Let's say we found him on Tinder.
Oh, I mean,
and let's say he had like the most chatted. Like, this guy looks like at least he thinks he's a Chad. He probably would have like the chattest profile. Like, if you're under, if you don't make X, swipe left. Just keep swiping, ladies. Yeah.
No, you're right. I mean, there's lots of judges engaging in this behavior, but they didn't put themselves in position. They didn't put out pictures. That's really the issue here.
But that then this turns into more of, it's not that you did it, but it's you drew the attention onto us, which that shouldn't be the way that shouldn't be the disciplinary reason, because then it turns into, if you stay quiet, it's okay. Well, no, either it's okay when you're quiet or you're out and loud doing it, or it's not okay. Like, it's not okay, period, is, I think, the real argument.
It's a tough one. Yeah, I mean, for instance, they brought up the issue of extramarital affairs. I mean, there are people across all professions, all over the place, who are doing that. Yeah, and have for forever. Joe, how you doing, buddy?
Hi, Joe.
Hey, Mike. Hey, Sean. How you guys doing?
We got a swinging judge here.
Yeah.
I have so many ways to interpret that statement.
Pictures of his
no. Like, he's literally he's a swinger.
He's a swinger in one of the worst places. He's in front of the Kansas Supreme Court on this issue, and believe it or not, they seem to be kind of okay with it.
What? That's Honorary Marty Clark. That's the swinger.
Yeah. Bottom right. He's the guy in the hot seat.
Well, he's the guy not wearing. He's the judge who's not wearing the robes. So that's why I assumed.
Yeah, he's having a bad day.
So, he's having a bad.
May it please the court. I believe I'm somewhat limited by the fact that Judge Clark decided not to file exceptions in this case after he retired. I do, however, want to address Justice Reagan's.
Let me just address that. No exceptions were filed, so really what we are here on is the appropriate discipline. Isn't that right, Mr. Joseph?
Unfortunately, I think that's what Rule 620 limits me to.
Well, no, it's not unfortunately. That's where we're at, isn't it?
Well, to me, it's unfortunate because I think the court has a can of worms and the potential to set some really bad precedent.
But I want to understand the posture of the case is we're here on what is the appropriate sanction in this matter.
That's right. Okay. Rule 620D limits me to talking about. I can make a statement with respect to the disposition of the case only. I do think, Justice, and I was going to address your question, that it would be appropriate for me to answer your question.
That's fine. I in preparing for this, I saw that, and my question was, seeing the time and the day in question seemed to imply that this was during, possibly, or I think the assumption I had was this was during work hours.
Right, and that would provide the connection that you see in the other cases where there's discipline, some connection to workplace conduct. I just wanted to point out that is in the record. That was addressed at the panel hearing. It was not a day when Judge Clark was working. He was not in the office. It certainly wasn't established by clear and convincing evidence that it was. So I think that what you were searching for, perhaps, was the hook between pure morality standard and some connection to his office. And the only
I wasn't necessarily searching. It just stood out to me. Okay, thank you.
Understood. So because of Rule 620, I am limited, as you mentioned, just talking about disposition. And the only comments I have is that he has since retired. So removal and suspension become irrelevant. The panel recommended public censure.
Mr. Joseph,
yes.
Do you have a position on whether or not this court has jurisdiction to impose any discipline, including censure, on a person who is no longer a judge?
That justice wants no part of this. He does not like this at all. And the guy before arguing said that the committee below, it was a unanimous vote for discipline. But he's got this guy in his team.
It's a good question. Being limited by 620, I didn't plan on researching or arguing.
Well, To me, that's within the. To me, that's entirely within the ambit of discipline.
Yeah, I want to get like a little more context so I can like really appreciate this. And maybe some people join late also, so perhaps it'll help them. But at least it'll help me, so I can like weigh in a little more intelligently. So this guy Clark here, during work hours, while he was not on duty, was engaged in swing festivities with a bunch of fellow swingers.
Well, what we have before us is that he was texting back and forth, and he was exchanging texts on a Tuesday, which we presume was during business hours.
Okay, and he's no longer a judge.
He's no longer a judge. He I think it looks like he retired in shame out of once this came to light, kind of thing.
Okay, so which is. All right, it's an interesting thing. You can see a parallel to the second impeachment as far as like now that he's gone, can we go after him and that sort of thing. Like that whole parallel there, which is an interesting concept. Because I guess if he wants to come back at some point, unretire, so in that case maybe he's relevant, which is the same thing that he done with Trump.
Yeah.
And he so this panel. This guy Todd Thompson. He's the one who's complaining.
He's effectively the prosecutor. Chris Joseph is his attorney.
Is there a morality statute or something guideline that he purportedly breached?
It's an ethics because he's a judge, so it was an ethics complaint.
But is there something written that they said you violated ethics rule XYZ? So it's a general morality clause. So. My question is there something saying specifically you cannot do something like this during work hours? Is there something saying you can't do this in general?
There's something that says equivalently, basically, I'm paraphrasing, but it's unbecoming for a judge to engage in this activity. So basic sort of ethics complaint stuff.
Yeah, and his argument is also like when you're the judge all the time, and that 24 hours a day. Your conduct should be governed accordingly to instill public trust and all that.
Which is definitely a fair position. I don't think
when he said
Americans take that position. Right? It's an interesting position.
Yep. Well, when he said that though, the 7 people above him did not seem to nod their head.
So, they didn't. They were basically like
that shocked me. This guy laid out a nice case, and they weren't like rude or anything. They we respect that position, and then they just hammered him with questions.
Yeah, that's Thompson. They got him.
Yeah. They're all on him like, we're delving too deep into this guy's private life here.
And basically, they don't want their own private lives being
absolutely. Absolutely.
This is totally a survival, self-interest type of thing.
Absolutely.
Yeah. And I think it's an important question whether or not someone who's no longer a judge, because the code, by its terms at least, only applies to judges. It doesn't apply to retirees.
Right. And particularly Judge Clark is not an attorney as well. He is a lay judge. So he is done. He's not going to practice. He can't. Some judges, there's a concern.
Oh, I didn't catch that. They said he's a lay judge, so I guess he's a magistrate. So this is like a low-level guy. So I guess what they're saying is, well, there's really no ethics complaint for the purpose of like his bar. Like, if I was a judge and just retired, I'm still an attorney.
Oh, wait. No, they said he's not. Oh, I guess
he just said lay judge. I didn't catch that the first time through.
Wow. So,
and I mean,
I can't stand that where places let you be a magistrate without actually having a law degree.
I know, and every phrase that comes out of their mouth sounds bad in this context, and lay judge isn't working either.
Yeah.
You saying?
That's it.
I like that. The swinging lay judge.
The swinging lay judge. I might have to change the thumbnail.
If they leave the bench, then become a practicing lawyer, and that is a hook, if you will, to keep jurisdiction over him. That would not be present in this case. Judge Clark is retired and not returning to the practice of law because he's not a licensed lawyer. I think the court can do whatever it wants to do under the rule. You can find no violation, dismiss it. You can impose any of the discipline options, or you can find there's no jurisdiction because he has since retired and is no longer. There's no possible future conduct. So yes, I agree that is an issue. One which I didn't brief, again, because we didn't file anything and didn't have any exceptions to make. My only suggestion in terms of disposition, if the court does accept the panel's recommendation for public censure, I would encourage the court to craft this in a way that does not set precedent that becomes an unfortunate precedent for future issues that might come before the panel on questions of morality. I think Justice Wilson pointed out correctly that drinking was a moral objection, homosexuality was a moral objection, both of which you could write language following this panel's rulings that could create something that's troubling for future generations based on what I see to be a reasonable person standard the panel suggests for determining morality. So whatever you do, my only suggestion, if you take the public censure route, to craft this in a narrow way that does not create problems for things that may seem problematic to a reasonable person in 2021, such as drinking or homosexuality used to be a problem morality-wise 30, 40, 50 years ago. I don't want the court to create something that's a problem for us, the generation appearing, my kids appearing before the court in 2050.
Counsel, go ahead, Justice Wilson. Counsel, but isn't it appropriate for the court to look at what the societal mores and expectations and accoutrements are at this time as opposed to what they were 50 years ago?
So the issue to me is when is discipline appropriate? And I presented my arguments to the panel and they disagreed. But my response to you would be the same as was the panel, which is you don't know. I don't think you look at morality as a basis, especially some of these private sexual morality as a basis for discipline, unless, like these other cases, and why I referenced Justice Rosen's question, unless there is a connection to the job. And you'll see all the cases cited in the briefing. You know, there's always some kind of hook to that, such as pornography while at work, such as saying something to a clerk or showing a picture to a clerk who works for the court. Or, things that aren't present in this case because that Tuesday was not a work.
I think, counsel, mores are different from morality. I think mores is a broader concept of just general expectations of how society expects people to act and whether or not there's some objective line or some clue that we can use.
It's dangerous to try to do that. I'm not. My position is the court shouldn't venture into that realm. It's dangerous to do. Again, 50 years ago, homosexuality would have offended most folks in society. And it shouldn't. It should not be a basis of his private life with no hook to his role as a judge. Again, I don't want to try to tread upon Rule 620 and try to backdoor in arguments because we did accept. We did not file exceptions. But I do think it's a slippery slope. So to the extent that you do craft public censure, I do worry about setting precedent that becomes a problem. That this reasonable person standard is awfully difficult to apply. And who is the reasonable person? Is the reasonable person a member of a small religious community in southwest Kansas? Is it the broad state of Kansas? Who is this reasonable person that sets these mores or morality standards? And I don't know that you can do that. It does become a slippery slope issue.
I appreciate that you're trying hard not to tread beyond where you should go, but maybe our questions are pushing you that way. And since there's time on the clock, the question occurs to me, it's a policy question really. When we ask these questions of mores or morality, does it make a difference that this judicial position is a publicly elected one?
Well, you'll see in the case law, there are many of the cases that were cited and discussed in our briefing where, for example, Pennsylvania and some other courts who considered affairs and morality suggested that there should be a line that doesn't go to this particular question. It just shouldn't be part of discipline because these are better resolved at the ballot box. For example,
Right. The idea is if his constituents don't like it, they can vote him out.
Right. And several courts have taken that position. It seems informed. I like that position. The other position that I like quite a bit is that without some kind of hook that ties the conduct into the judiciary, you shouldn't be going there at all. In this case, you had a complaint by a resident of Missouri. It's not. There's no conduct that involved work. Because of that, if that Tuesday at 2:16, if Mr. Thompson had established by clear and convincing evidence that Judge Clark was working that day, you'd have that. You'd have something there. But he wasn't there. It was a private, personal phone. He was out of the office. There really is no connection other than the woman with whom he did not actually have an affair, suggesting something would be some fantasy of being in chambers at one point, again, on his private, personal phone text message. So there's no hook that ties it into his role as a judge. And frankly, when you're looking at strictly questions of morality, those can be resolved at the ballot box, or otherwise if he is out of sync with the standards of his community.
Counsel, in Ray Romey, the judge made fun of a prostitute during sentencing by giving her sentencing in verse. And in that case, it was found that that behavior was so egregious that he was removed from office. Later on, he was elected by the voters to that very office. So I would argue that both the court and the voters exercised their discretion in attempting to do their job as they saw fit. Can you distinguish that case from this situation?
Yeah, absolutely, because what you've described, again, is conduct related to his performance of his job. If Judge Clark had made inappropriate comments, not even just in chambers, but at the courthouse, there's something tying it into the job. Here it is, completely private, personal, out-of-court behavior. There's nothing tying it into his role as a judge. He didn't even do it during the work hours. This is regulating the bedroom, essentially.
I have a question. Let's take morality out of it, okay? Let's not even talk about morals. Let's talk about that the complainant in this case opted to file a complaint instead of posting this picture that he had in his possession of the judge naked or body parts, and instead posted that on his Instagram account, and it went viral. Does that affect, as the code says, public confidence in the judiciary or promoting integrity?
That really gets into the blackmail issue, if you will.
I was saying this earlier. Ron was here earlier, and I was saying this. I came at this clip with the worst of intentions. I thought, okay, this is salacious. I'm going to have fun. And then I started watching it, and I'm like, it's really interesting. Both attorneys, great cases. The justices are asking great questions, and it's an interesting discussion.
Yes, it is. It's a very interesting discussion.
Well, and I think that judge does bring up a good point. Like, if we discipline a judge, but the people of that community say, actually, we're cool with this, what does that say? Yeah. And I do think that's an interesting issue.
Well, what do you guys think? Do you think that morality should be legislated with respect to people who are holding public office? And is there a difference between judges and politicians? Is there a difference? Like, should this sort of thing be legislated, or should that be left exclusively to the ballot box?
Yeah, I mean, these are all good questions, and like, for instance, with politicians, they're nowhere close to this standard on average. Yeah. So this is definitely trying to raise it for a judge, but this is a wrinkle I didn't get, that he's a lay judge, so he's not even a member of the bar.
So yeah, you can't really discipline a guy. Like, what are you going to do? Take my law license away? Yeah.
Well, then this justice asks a damn good question, because they have me convinced. Let's stay out of his bedroom, whatever. Let the guy go. Then she says, okay, fine. What if he posts it on Instagram and gets 10,000 likes? Does that change your analysis? I mean, these are uncomfortable, rough hypotheticals.
Yeah.
They really are.
I'll tell you this much. Here's my starting. I have a couple of starting points here. Okay, I recognize that if I were to use my own personal morality standards for who should be a judge, there probably would be like a dozen people eligible.
Right.
So when I'm trying to approach this, I remove my personal perspectives on things, because I recognize that's not fair yardstick to hold society to a large, and that society has different values than I have, and I'm not the one in control of society. And I think each of us might have different values, in certain areas of society at large. So it's sort of important to step out of that and just look at, what's right or wrong in the abstract rather than from a personal perspective. With that in mind, to me it makes sense to sort of try and draw a line based on a few factors here. If the judge is someone who's using his position in order to promote something that's considered salacious, like imagine a situation where he's like in his courtroom and doing involved in lewd or lascivious type of activity. Right. That's something that I think that certainly now you're basically using your position to embarrass the structure of the judiciary. So that I would think that they can come down very hard on that, and should. Even if he refers to himself as the judge, here comes the judge in some sort of sexual type of way. I think he's now at that point, if he himself eschews that rather than the third party attaching to him. But I think if he himself is embracing that sort of perspective, that is someone who's basically embarrassing the judiciary and certainly is asking for sanction. Let's just say he or she would be acting in an individual capacity and almost hiding the fact as far as their role in the judiciary and things of that nature. While I personally might frown on that activity, I think it's bad, I don't think our society at large probably frowns on it nearly to the same degree that I would. We have to recognize that, all right, most people are looking at might not even realize this person has anything to do with the judiciary.
Right.
So, and whether he sends it to 10 people and it stays with those 10 people, or whether he sends 10 people and it ends up going viral, I don't think there should be a difference, because his conduct, his activity as far as what he sent it out, I don't think the virality of the share should play a factor at all.
Yeah.
Because you cannot control what's going to go viral, and it's very hard to know or gauge. And just because I sent it to 3 people and some of them end up jacking it up and it does go viral, that shouldn't mean that I get more of a punishment than someone else does the exact same activity to me and it stays relatively quiet. I don't see how that's a fair factor to even bring into the equation, personally.
No, that's interesting, and that is a big difference between now and, say, even 10 years ago.
Yes, for sure. And we have to carve rules going forward, not looking backwards.
But we're all hip to that because we're YouTubing here.
Yeah.
I'm not talking about blackmail. I'm talking about the reflection on the judiciary. And you could say also, if I post a Twitter a tweet that says "F the president,"
sure,
in my own time, on my own phone, on my own private Twitter account, does that reflect well on the judiciary? Does that promote integrity and public confidence in the judiciary?
No, I agree that's a bad set of facts, and you don't want that. Likewise, if somebody hacked into your phone and took one of your private pictures off, which unfortunately can happen, and posted that would be...
What happened here
was
intentional putting out there for public dissemination.
No, it was as if I sent a naked picture to my wife.
Isn't it foreseeable? Well, no. Wouldn't it be foreseeable that somebody would... don't we do
He's
that?
He's totally sent a naked picture to his wife.
Realize that if you post something...
that was confession.
This was not on social media. This was only one person.
The old adage of don't...
That sample really was a little too natural, wasn't it?
Yes, that was a fun report.
Yeah, he's like, suppose I sent a picture. For sure. Suppose I sent the naked picture to my wife while I was on a chin-up bar, and I was like, some were going down, some were going up. One time I had my leg up in the air. What are you telling us?
Yes.
What the hell?
And suppose my wife responded back with a bunch of volcanoes.
Don't write anything down that you wouldn't want on the front page
of the Wichita Eagle.
I agree. It is risky in the sense, but it's also likewise risky if you send a naked picture to your wife. The same risk attaches. I mean,
right.
This very well could happen. I mean, whether or not it is. I mean, it's essentially what you tell your kids. Don't take naked pictures of yourself. Don't do these things because don't write an email. No, I agree with that. It's not wise because there can be issues. That said, where does the court come in? If it wasn't posted anywhere, the only reason this became a matter of public knowledge is because it went to hearing, and here we are. Otherwise, it wouldn't have.
A member of the public complained about it.
Yeah, to Mr. Thompson, who put the pictures in the record. Yeah, otherwise nobody.
And we'll leave it there just because we have definitely run longer than we normally do on a Part A. Come back tomorrow. We will pick it up where we left off here. 1 minute, 1 second left on the clock for the defense. And, of course, the rebuttal still to come. And, of course, a conversation with Mike and our fellow lawyers on the panel. So until then, of course, we'll have our frauditors, auditors, subsets in the evening. And the final with Richard C. Hoagland in our debate about curiosity and is there things we don't know in the moon. Till then, like, share, and subscribe, be kind to one another, and of course, release the Krakens as we march along this afternoon and every afternoon here from day one. Have a great afternoon. We'll see you